All right, today we're jumping headfirst into the high-stakes world of criminal law. We're talking about one of the most powerful pieces of evidence you can imagine, a confession. But getting that confession from a police station into a courtroom, well, that's a whole lot more complicated than it looks on TV. So let's unpack this.
I mean, it seems pretty straightforward, doesn't it? Someone says, I did it, case closed. But the law, and for very good reason, is super cautious. It has to ask, was that confession obtained fairly? Is it actually reliable? Because, let's be honest, a confession made under intense pressure isn't always the truth.
And that's exactly what we're going to break down. See, across Australia, there's this really complex web of laws that control police interviews. Before a jury ever gets to hear a confession, it has to clear a whole bunch of very specific legal hurdles, and we're going to map out what those are.
So here's our game plan. First, we'll talk about why just saying the words isn't enough anymore. Then, we're going to decode the four main ways confessions are recorded across the country. After that, we'll look at the exceptions, the reasonable excuses. We'll see what happens when the rules get broken, and finally, we'll put it all into perspective with some other key rights.
Okay, so let's kick things off with the single biggest idea that has totally reshaped police interviews in recent decades. The law has had to face the reality that unrecorded confessions can be unfair or just plain wrong, and its answer was to bring in a really powerful safeguard. And this is it, the requirement for an audio or video recording. Now, this isn't just some good idea or a matter of police policy. In many parts of Australia, it is the law. The whole point is to create an objective, undeniable record of what was said. This protects the suspect from being pressured, and it also protects the police from any false claims. Now, because Australia is a federation, we've got different laws in different states. But instead of getting bogged down in some boring state-by-state list, we can actually understand the entire system by grouping the laws into 4 different approaches. And it all comes down to one thing: what triggers the need to hit that record button?
And this table here breaks it all down for us. The real difference between these 4 groups isn't just which states are in them, it's about when that obligation to record kicks in. Is it for any admission, no matter when? Or does it only count during a formal interview? These little differences in wording, well, they have huge consequences in the real world.
So first up is Group 1. The easiest way to think about this is the always-on camera approach. Basically, the rule here covers almost any admission a person makes, whether the police were expecting it or not. As soon as the police have a suspect, that recorder should be ready to go. This approach, which you'll find in Victoria, WA, and the Northern Territory, is by far the broadest. It's designed to capture everything, even a spontaneous comment made in the back of a police car. The goal is to stop any arguments later about who said what. If it's not on tape, or at least confirmed on tape later, it's probably not getting into court.
Okay, so from the always-on camera, let's move to Group 2. This is more like the interrogation room camera. The duty to record isn't constant, it's specifically linked to a formal police activity.
And here's where you really see the contrast. In New South Wales and Tasmania, the key legal phrase is in the course of official questioning. So what does that actually mean? Well, it means a random comment made before the formal questions start, or maybe after they've ended, might not be covered by this specific rule. It carves out a very clear period of time.
Moving on to our third group, South Australia zooms in even tighter. The rules here aren't just about general questioning. They are tied directly to the formal procedure of a police interview, which has a very defined start and end point.
But what's really fascinating about South Australia is its incredibly detailed backup plan for when recording just isn't possible. It's not enough to just write things down. Police have to then videotape themselves reading that written record to the suspect, and they have to capture the suspect's response on camera. It's this double-check system designed to leave zero room for doubt, even if the primary tech fails. And finally, we have Group 4, which we can call the suspect camera approach. Used by the Commonwealth, the ACT, and Queensland, this rule isn't just triggered by the act of questioning, but by the official status of the person in the room.
So what exactly is a suspect? Legally, it's this gray area, right? It's somewhere between a simple hunch and being dead certain someone did it. And you can imagine pinpointing the exact moment a person goes from being a witness to an official suspect. Well, that's where a lot of the legal battles happen, because that's the moment the recording rules kick in.
But of course, the law has to deal with the real world. Things go wrong. So what happens if the rules just can't be followed for a good reason? Well, all of this legislation has a series of reasonable excuses built right into it.
And these are the typical arguments you'll hear in court.
Maybe the camera broke, or the suspect just flat out refused to be on tape. Or maybe the confession happened at a really chaotic crime scene where setting up gear was impossible. It's up to the prosecution to prove one of these excuses, and believe me, it's a critical hurdle for them to clear.
Okay, so what if the police mess up? There's no recording and they don't have a good excuse. Is that confession automatically thrown out? Well, not always. This is where a judge's discretion becomes so important. Think of this as a critical safety valve in the system. It lets judges look at the big picture. Why weren't the rules followed? How serious is the crime? Does the evidence seem reliable anyway? And then decide if letting it in would be against the interests of justice. And that is a very, very high bar to get over.
And here's the kicker. Even if a judge does decide to let the unrecorded confession in, they can't just pretend the mistake didn't happen. The law says the judge must tell the jury that the recording rules were broken and then give them a warning about how carefully they should treat that piece of evidence.
Finally, let's just zoom out for a second. It's so important to see that these recording rules don't exist in a vacuum. They actually work hand in hand with other fundamental rights that are all designed to make sure the whole process is fair.
And two of the biggest are the right to remain silent and the right to call a lawyer. I mean, think about it. The video recording creates a perfect, objective record of what happened. And these other rights make sure the person in that video is fully informed and properly supported. Together, they create a much fairer system.
So why does all this legal nitty-gritty actually matter? Because at the end of the day, this is all about the integrity of our justice system. These rules are here to make sure evidence is reliable, to protect people from unfair pressure, and to make sure we can all have faith in the verdicts that are delivered in our courts.
Which leaves us with a really big question to ponder. Is this complicated web of rules the best way to protect the innocent? Or does it sometimes create an obstacle course that makes it harder to get to the truth? It's a critical balancing act the law is always trying to get right. Thanks for joining me for this explainer.